Good afternoon, everybody, and welcome to today's webinar organized by the Singapore International Arbitration Center. Exactly 10 years ago, in July 2010, SIAC published new rules applicable to arbitrations administered by it. The rules provided two new provisions for parties, the first in relation to emergency arbitrations, and SIAC was in fact the first in Asia to offer emergency arbitration rules, and the second that allowed an expedited conduct of the arbitration. Both procedures have been successful, and as of last week, SIAC has successfully administered 107 emergency arbitrations in the last 10 years. Emergency arbitrations offer a party in need of interim relief the opportunity to seek such relief from a tribunal that is quickly put together, and any emergency award remains in place until the main tribunal is constituted and reviews it at a hearing akin to a return date in court. SIAC has received and administered applications for emergency relief in a broad range of sectors, including shipping, distribution agreements, joint venture agreements, international trade disputes, construction disputes, and so on. And the types of reliefs are also varied. Parties have chosen to use the emergency arbitration provisions to seek preservation orders in IP, freezing orders, and even anti-suit injunctions. Having introduced the topic, may I introduce our panelists today. We have, and I take this in the order in which they're going to speak, Chuan Thye, and I have his permission to refer to him as CT, a partner at Raja & Tan in Singapore. And he will speak about emergency arbitrations versus interim reliefs. Which should one approach and why? We have Ben Giaretta, a partner at Vivekananda in London, who will speak about emergency arbitrations in practice. Vivek, a partner at Allen & Gledhill in Singapore, who will speak about enforcement of emergency arbitration awards. And finally, Sharan Jagtiani, a senior counsel at the Bombay High Court, who will speak about steps after the award, including constituting a tribunal and the status of awards under the Indian Arbitration Act. A bit about myself, I am a barrister at 39 Essex Chambers in London and have been in practice for about 14 years. I have a cross-border practice representing Indian clients in English law governed disputes at the High Court in London and the DIFC Court in Dubai. About 50% of my practice is litigation and about 50% is international arbitrations, mainly seated in London and Singapore. I started my career as a counsel at the Bombay High Court with Sharan, one of our panelists, although I'm many years as junior, and run a set of chambers in Mumbai where I spend the English court vacations. And so my juniors in Mumbai also specialize in cross-border disputes. Before I defer to CT for the first topic, are we able to pull up the first poll, please? So we've tried to make the webinar interactive, and you will see on your screen a poll that comes up, and we would be grateful for your responses. Are we able to perhaps stop the poll and publish the results? So this is interesting. We have many counsels. 33% of you are counsels, and 33% of you, or 36% of you, work in law firms. And we also have a number of students. Welcome to you. And this is great. We have 64% of the audience that has worked on an international arbitration before, and 33% who have worked on the SIAC. So with that, if I may introduce our first speaker, CT. CT is a senior counsel of the Supreme Court of Singapore and a fellow of the Chartered Institute of Arbitrators. He has been in private practice for almost 30 years and has a broad commercial, corporate, financial, and infrastructure dispute resolution practice. The practice has a wide geographical scope, and he represents a range of domestic and international entities. CT is also recognized as a leading restructuring and insolvency lawyer and is a fellow of the Insolvency Practitioners Association of Singapore. He has sat as an arbitrator from about 10 years ago and is on the panel of arbitrators of the ICC, SIAC, and the AIAC. Of particular relevance to today's webinar, he has been involved as an arbitrator and emergency arbitrator in various proceedings involving Indian businesses, as well as the Indian jurisdiction. And with this, CT, if I may defer to you for emergency arbitrations versus interim reliefs in court.
Thank you, Karishma. I get the easy bit today. I get the fairly general bit that talks about why you should resort to emergency arbitration as opposed to courts. I think the starting point is this. By definition, we are in a situation where one is considering urgent relief, and therefore time it is going to be the main consideration, at least in the initial stages. So we'll start first with the idea of jurisdiction. You will be familiar that the ability to arbitrate depends on the existence of a written agreement to arbitrate. So there usually isn't much of an issue about jurisdiction. You contrast that with running to a court for interim relief. The question is what is the basis or on which a court is going to found jurisdiction? Different courts will have different rules as to how they found jurisdiction. The Singapore and the English courts, and I think the Indian courts as well, find jurisdiction on the basis of the ability to serve proceedings. And if you need to serve out of jurisdiction, you need leave for that. So jurisdiction is the first hurdle. The other point, and I think this is what led to the SIAC introducing this idea of emergency arbitration 10 years ago, was a reluctance on the part of the courts to grant relief where there was an agreement to arbitrate. This was part of the court's deference to the idea that if parties have agreed to arbitration, then that should be the first port of call. There was another problem with going to court, and that was courts tended to interpret, or at least courts outside of England tended to interpret their ability to grant to make orders in aid of arbitration seated outside of their jurisdiction rather narrowly. So you had an issue where if you needed relief, you went to the court would say, well, too bad, sorry, this is happening, for example, outside of Singapore, and Singapore actually had to amend its arbitration legislation in order to provide for that. So related to the question of jurisdiction is the question of service. Again, most arbitrations will arise out of an existing agreement. That agreement would have notice provisions. Those notice provisions would allow for fairly efficient means of communication and the giving of notice. Contrast that again with court rules on service and the sort of difficulties that one tends to run into with those provisions. I think the current pandemic we all find ourselves in has only highlighted the need for probably a review of most service provisions. Although I do accept that in most courts now there is a willingness to be fairly innovative about substituted service. But again, that is something that requires an application, requires argument. The third point as to emergency arbitrated relief is one of timing. I think in the 10 years that since the SIAC has introduced the idea, most of the institutional rules have landed on a fairly common sort of timetable. The application is usually made with the notice of arbitration. Once it's accepted by the institution, then the appointment, once it's accepted by the institution, the appointment of the emergency arbitrator takes place within a matter of days, usually 2 days. And once that happens, the emergency arbitrator again has about 2 days to establish a schedule for hearing, and he will then have to make his decision within 2 weeks of his appointment. And I noticed that I was wrong. The SIAC actually shortens it. They make the appointment within 1 day of accepting the application. It's probably worth noting that the ICC rules are different. The ICC rules are different in the sense that they allow what we would be familiar with as ex parte applications. You can make the application for emergency relief with the you can make the application actually before filing the request for arbitration, although your request then has to go in within 10 days of the application itself. And while the ICC rules use a formula that or form of words that say as short a time as possible for both the appointment of the arbitrator as well as the establishment of the schedule, they do say that it should normally take place within 2 days. I think with the best will in the world, courts are hard-pressed to match this sort of timing. So when we're in the realm of urgency, then I think the timing speaks for itself. And I think in India, you are probably fortunate in having judges with a fair amount of experience. That's not always going to be the case in jurisdictions where you may be seeking relief. Certainly, in parts of Asia and other parts of Asia, you do have courts which are not necessarily experienced in commercial matters, and they don't hear a lot of them. And so you are looking then at the question of who do you have making the decision as to whether or not you should get interim relief. And I think in most institutional arbitrations which have the provision for emergency arbitration, they draw from their panel of arbitrators for this purpose. And I think the panel system has over the years established a certain consistency of quality and experience. The next point, and I think Ben will probably elaborate a little more on this, or we can discuss it a little bit more. The point is this, if you're in a court proceeding, the principles and the procedural rules that determine whether or not the application would be granted will very much be a localized thing. And it's a question of how the court would exercise its discretion in terms of granting that relief. When we're in the sphere of international arbitration with international parties looking at a certain consistency in how their contracts are to be performed, and a certain expectation of consistency as to the circumstances under which they would get relief, it's important to note that what seems to have been developed, and I use the word seems because I think most commentators accept that by definition, arbitration is not a system of precedent, and you don't get a lot of published awards and therefore not that much guidance in terms of how arbitrators would approach a question. But by and large, and I think a commentator like Bourne would summarize it in this way, that it's that the tribunal emergency arbitrator will take into consideration are one, a risk of serious or irreparable harm to the claimant, two, urgency, and three, no prejudgment of the merits. While that sounds very similar, I think, to the test in American cyanamide, that is different in a way, because the approach to the question of a prima facie case, the question of approach to irreparable harm has been wider and less stringent than most court jurisdictions. So that leaves a certain open texture to the question. And from a practice point of view, it's important because, again, in an urgent situation, the clients may not have time to engage local counsel in the courts, and therefore being able to work off a set of, I think, what are called transnational principles would be fairly useful and helpful. Now, obviously, there are exceptions to this idea that you would run to emergency arbitrator rather than the courts. The most obvious one would be enforcement, and I think there will be a fair amount of discussion about enforcement, so I won't say too much about that, just to make the point that there is a question mark over whether the interim award by an emergency arbitrator is enforceable under the New York Convention. Jurisdictions like Singapore and Hong Kong have amended their arbitration legislation to expressly include or provide for awards by emergency arbitrators to be recognized as awards and therefore enforceable. The second situation would be where you actually need the penal consequences of the non-compliance of a court order. And usually that's in a Mareva or a freezing order type of situation. And associated with that, where you actually need to restrain a number of other parties who are not parties to an agreement to arbitrate. And there are situations where you do need to proceed without giving notice. Again, usually in a Mareva or freezing order situation. And it's worth noting that it's only the Swiss rules of arbitration that provide for proceeding without notice. And in Article 26.3 of those rules, they provide that in exceptional circumstances, the tribunal may rule on the request, although what is required is that at the earliest opportunity, then the other party will be granted an opportunity to be heard. There is one point which I think will certainly come up later in this discussion, and that's where, and that really is the question of whether, if you've opted for a certain set of rules, the courts in the jurisdiction continue to retain an ability to grant interim relief, or whether your first port of call necessarily needs to be the emergency arbitrator under the chosen set of institutional rules. Okay, I think that's my general overview, and I'll hand it back to the moderator.
Thank you very much. Thank you, CT. I believe Vivek has a point to make.
Yeah, thanks, Karishma. I just wanted to make 2 points on what Chuan had to say. One is that in making the choice between going to an emergency arbitrator or going to a national court, quite often it's a function of who the counterparty is, I believe, and where your counterparty is based. I mean, if your counterparty is, say, a party that is incorporated in Singapore, it may very well make good sense to approach an emergency arbitrator. but it may very well be that your counterparty is in a jurisdiction where you are better off approaching a national court to get interim relief at a quicker pace, or for it to be more effective, also with respect to enforcement, as we will discuss. The second thing I wanted to say was that sometimes this is not really a choice. And I'm thinking back to the time, particularly after 6 September 2012, when the Balco decision came out, and interim relief in terms of Section 9 in the Indian courts was not an option. So parties who required interim relief could only go to an emergency arbitrator if they had signed on to an SIAC arbitration. Similarly, for instance, I understand China doesn't really provide for interim relief at all in relation to foreign seated arbitration. Now, even in Singapore, for that matter, the Singapore courts do tend to take the view that if you have an option to obtain interim relief in the arbitral process, then there is lesser need for the courts to intervene unless there is an issue of extreme urgency. So I think I just wanted to add that is that it may not always be a clear option of one or the other, and it may require some careful evaluation in each case.
Thank you, Vivek. Yes, I'd just add to that point that it depends, doesn't it? And it also depends on the kind of relief that one is seeking. So, Vivek touched upon the point that it depends on where the parties are situated, but perhaps a relief such as an anti-suit injunction is easier to obtain and enforce because the parties to an emergency arbitration are bound. But a freezing injunction may not be that effective, not least because you'd like to serve the freezing injunction on various banks and other assets, and confidentiality provisions may also prevent one from doing that. But thank you very much, CT and Vivek, and may I move on to our next panelist, Ben. Ben is a dispute resolution lawyer specializing in international arbitration. He's a partner at Mishcon de Rea in London and was formerly a partner and head of dispute resolution for Asia at Ashurst LLP based in Singapore. He's regularly appointed as an arbitrator and has been sole arbitrator, party appointed arbitrator, presiding arbitrator, and also emergency arbitrator. He's on the panel of arbitrators of various institutions, including the SIAC.
Hi, we're not able to hear Karishma, so we'd like Ben to share his views.
Okay. Thank you very much. So thank you for inviting me to take part today. I'm going to say a bit about the procedure of an emergency arbitration. And I'd like to highlight quite an important point, which is that the emergency arbitration process is very different from a normal arbitration process. In fact, I would say it's very much sui generis, it's very much of its type. And it's important for when a party is engaged in emergency arbitration to appreciate that. But let me just highlight a few characteristics of emergency arbitration to support that proposal. Firstly, very obviously, the decision of an emergency arbitrator is interim and not final. And it's interim in a number of different ways. Firstly, as has already been mentioned, the tribunal, arbitral tribunal, when it's finally appointed, can change the decision of the emergency arbitrator. But more than that, the emergency arbitrator themselves can change their decision. The SIAC rules say that the EA can modify or vacate their emergency arbitration award. And that's very highly unusual. A normal arbitrator cannot change their decision. Another characteristic is that the test to be applied and the process as a whole is rather unclear. Most arbitration rules do not set out the process in any specificity, in any detail. And on top of that, they usually impose quite a tight timetable. It's usually around 14 days, as has already been said. And that has quite a number of important consequences, but one of them is that emergency arbitration is not really an area that non-lawyers would happily step into. If one thinks about the history of arbitration, it's always been set up to allow a wide range of participants, whether lawyers and non-lawyers, though I appreciate that it has become rather dominated by lawyers in more recent times. But emergency arbitration in particular is really set up for the lawyers to run, for the lawyers to represent the parties, and for the lawyers to be arbitrators. And that's different from normal arbitration. Another factor is that it is inter partes. Now, that sets it apart from court processes in many countries, of course, where one would obtain an emergency injunction on an ex parte basis. But inter partes in this context does set emergency arbitration apart from normal arbitration, in particular because although it is inter partes, effectively it makes life very difficult for the respondent. In fact, when an emergency arbitration starts, the emergency arbitrator normally has the power to issue a preliminary order reserving the position until the final hearing in the emergency arbitration. And that really is effectively ex parte. The respondent has no chance, for all practical purposes, to get up to speed within the time available. And even when they get to the final hearing, they're very much up against it on the respondent side. The claimant side may have had quite a bit of time to prepare within the context, of course, of the overriding emergency that it perceives. But the respondent has even less time. If you think about it, you're sitting there at home at the weekend, you've got this emergency arbitration notice appearing out of the blue, and you've got to respond within a couple of days to comment on the timetable, and within the next 2 weeks, you've got to assemble all the evidence, you've got to take instructions from your client, you've got to turn up at this hearing. It's pretty crazy, I must say. And so it's although this is inter partes, it's inter partes in a very special way, very particular way. Now, of course, I should, of course, acknowledge that an emergency arbitrator is always aware of this and will always make allowances for this. But you yourselves, when you embark on emergency arbitration, must also appreciate that it is very different from a normal arbitration. Another factor I want to mention is that the emergency arbitrator has the opportunity to postpone their decision. No normal arbitrator in normal proceedings can postpone their decision. An emergency arbitrator can come to the view that this particular question in front of them is not for them to answer, but is for the main tribunal to answer. And that's pretty extraordinary as well in the world of international arbitration. Another point is that emergency arbitration operates really without the supervision of the courts. And there's a very interesting concept built into this as to what is an emergency arbitrator. Is it really an arbitrator under applicable procedural laws? And do the powers of the court apply to it? But we might talk a bit later about the Minder against Yushin decision, which is the decision of the Delhi High Court from May. But I just want to highlight one point out of that case, which is that case was done under the JCAA rules in Japan. Now, the JCAA rules are rather unusual in their emergency arbitration provisions because it says that the decision of an emergency arbitrator shall be deemed to be a decision of the main tribunal. So it expressly links the two together. And that word is not found in other arbitration rules. And that has a very important consequence as when we talk about the Minder case, but it has a very important consequence because it means that the supervisory powers of a court apply to an emergency arbitrator under the JCAA rules. And that's not necessarily the case under other arbitration rules, which don't have that express provision. Under other arbitration rules, one could define the emergency arbitrator not as being standing in the shoes of the tribunal, but actually being a representative of the arbitration institution, or as being an entirely separate beast, entirely separate animal that is not covered by any of these laws at all. So potentially, depending on what rules you're operating under, the emergency arbitrator could be operating outside the supervisory powers of a court, which is very, very strange, very unusual. And finally, this is the topic that we talked about in more detail in a second. Of course, there is doubt as to whether the decision of an emergency arbitrator is enforceable or not throughout the world, as things are currently set up under procedural laws throughout the world. Chen Thye has already mentioned that Singapore had to change its law to make emergency arbitration awards enforceable. Well, the implication of that might be taken to mean that Singapore has accepted that EA awards are not covered by the New York Convention and therefore not enforceable throughout the world under our current system of arbitration. And that again creates very strange dynamics within the emergency arbitration procedure because you are working towards something that is potentially not enforceable at the end of the day. And what does that mean for the parties' attitudes? Perhaps the respondents will just sit back and say, I don't care about this because this decision will never be enforceable. So I've been involved in a few emergency arbitrations, and on the whole, I found them to have worked and to have operated effectively. But throughout these emergency arbitrations, I've always thought, are we suspending our disbelief here? What is really going on? So I find the whole emergency arbitration process rather odd, actually. Karishma.
Thank you, Ben. And I think that takes us very efficiently into the next topic, which is whether or not emergency arbitration awards are enforceable. And we have Vivek, who is a partner at Allen & Gledhill, Singapore, who is going to address us on this topic. Vivek's areas of practice include international arbitrations and commercial litigation with a focus on India. Vivek has experience acting as counsel on several Singapore-seated arbitrations, including emergency arbitration proceedings and expedited arbitrations. Vivek was previously a deputy registrar and head South Asia at the SIAC. I guess that's perhaps many times Shweta's senior, if I may put it that way, and was also in private practice in India before his time at SIAC. Vivek, would you like to perhaps develop on the point that Ben has made about enforcement?
Yeah, thanks very much.
And
Karishma.
difficulties with enforcement.
Sure. Thanks very much, Karishma, and good afternoon to all of you. The starting point in talking about enforcement, as I think you've heard from both Chuan and Ben, is of course the New York Convention. I think that immediately springs to mind whenever you talk about enforcement in the context of international arbitration. The New York Convention, of course, I think is the bedrock of the success of international commercial arbitration because it provides for the enforceability of awards across now about 164 countries globally. Now, the question though, in the context of what we are discussing today, is whether decisions of emergency arbitrators are covered by the New York Convention. And I think the general view, and I do share that view, is that it probably is not. The reason for that, one is that the New York Convention itself, unfortunately, does not define what an award is, nor does the model law on international commercial arbitration, which many countries have adopted, including India and Singapore. So therefore, you are left with local legislation in terms of how they define an award and whether that in fact includes interim orders of tribunals or emergency arbitrators. And that's precisely what Singapore did, for instance, in 2012, to provide for the enforcement of decisions of emergency arbitrators by including interim orders of tribunals within the definition of an award, and also expanding the definition of an arbitral tribunal to include an emergency arbitrator appointed under the rules of an institution. There have been other jurisdictions which have followed a similar course, Hong Kong and New Zealand in particular. But apart from that, the general view does seem to be that absent specific legislative provisions, the enforcement of emergency arbitrator orders is definitely a big question mark. But Having said that, there are certain positive experiences in other jurisdictions, and I will speak about a few that relate to India in particular, where I think I've had some experience of being involved in those cases. Now, there have been jurisdictions like the US, for instance, where despite the lack of legislative provisions, there have been enforcement of orders of emergency arbitrators in certain cases, primarily with the view that the lack of enforcement or non-enforcement of such orders would affect the efficiency of the arbitral process. So there are countries where you have legislative provisions, and there are countries like the US, which have taken a slightly progressive view. And now coming to India, which I think is perhaps the most interesting experience when we talk about, well, enforcing emergency arbitrator decisions. Now, I'd like to think that enforcing is actually a wrong term. The right term would be how best can the courts assist in utilizing EA decisions or orders, or using EA orders to achieve an end result, which is the effectiveness of those orders. Now, firstly, it's not surprising that there is a considerable amount of experience from India in relation to this topic. And that's simply because there's been a large number of Indian parties that have been involved in SIAC arbitrations over the years. And there have also been a large number of Indian parties that have been involved in SIAC EA cases over the years. I understand in the past 10 years, there have been roughly about 45 Indian parties that have been involved in SIAC EA cases. Now, in India itself, in 2015, when the amendments were proposed to the 1996 Act after a long hiatus, one of the factors that was under consideration, we understand, is the Law Commission report, the 246 report, which in fact had recommended that the legislation be amended in such a way that recognition be granted to emergency arbitrators, and also provisions be introduced for the enforcement of emergency arbitrator decisions. But unfortunately, the 2015 amendment did not include these provisions. And likewise, when the amendments were introduced in 2019, there were no provisions introduced in the 96 Act for enforcement of EA orders. So we are then left with a similar situation in India, where there is no legislative provision for the enforcement of EA orders. But I will talk about three examples of cases which I think are quite interesting in the context of EA orders. And I do believe they're quite unique in that no other jurisdiction has had this kind of experience. The first of these cases is a case called HSBC and Avitel, which was relates back to an arbitration that commenced in 2012 when I was at the SIAC. There was an application made to the SIAC to appoint an emergency arbitrator. The orders that were sought in that case were freezing orders against the assets of the respondents who were located in India. The emergency arbitrator considered the application. He had a hearing and issued decisions, essentially directing or issuing those freezing orders. What the claimants did in that case was then to apply under Section 9 to the High Court of Bombay, seeking orders in similar terms as the emergency arbitrator's orders. And the Bombay High Court in that case did grant them similar relief. And in particular, the High Court did note that there was nothing that prevented the claimant in that case from applying under the Section 9 route to seek similar relief as the emergency arbitrator's orders, and that in fact it would be of assistance to the court to consider such orders. And in any event, the court also observed that such EA orders may be enforceable in other jurisdictions. So there would actually be some benefit in looking at those orders, even though they may not be directly enforceable. So that's the first example of, well, a utilization, as I call it, of an EA decision to achieve the same result in India through the Section 9 route. The second example is one that I was involved in as a counsel to the claimant in the SIAC arbitration and the SIAC emergency arbitrated proceedings. This is the case of Raffles and Educom, which was an arbitration that commenced sometime in 2015. We applied then to the SIAC to appoint an emergency arbitrator in relation to certain events that were ongoing in India, where we required certain injunctive relief against the respondents. We got the relief that we wanted from the emergency arbitrator. And similarly, we applied under Section 9 to the High Court of Delhi seeking similar interim relief against the respondents. Now, the reason for this was that while we had the SIAC order, we did need some teeth to the order against the respondents who were in India and who were based within the jurisdiction of the court. Therefore, we applied under Section 9. The Delhi High Court did grant similar interim relief as the SIAC Emergency Arbitrator. Now, the Raffles case is particularly interesting because it is quite often cited, I believe incorrectly, as being the decision that takes the view that EA orders are not enforceable in India. I think that position is undisputed generally in terms of the law. But what's important is that that particular decision that is quite often cited was really in the context of the objection as to the court's jurisdiction under Section 9 and whether the 2015 amendment actually even applied to that case. But what's more important in that decision of the Delhi High Court in Raffles and Educom is that the court again specifically notes that there's nothing that prevents a party from applying under the Section 9 code, even if it has already obtained, say, interim relief from an SIAC emergency arbitrator. So that again means that there is no inconsistency between the HSBC decision and the Raffles decision, in that you could apply to an Indian court under Section 9, armed with an SIAC order, even though the Indian court is obviously not bound by such an order, but can perhaps be persuaded along the same lines as an SIAC emergency arbitrator order. The last example I want to cite is another case that I was involved in as a counsel to the claimant in the SIAC arbitration and the emergency arbitrator proceedings, is a case that involved this movie called Hotel Mumbai, which was a Hollywood production based on the 26/11 attacks in Mumbai, starring, well, several well-known names. Now, what had happened in that case was there was a distribution agreement which the claimant held for distribution rights for the movie in the SAARC region, and particularly in India. Now, on the eve of the movie being released, that distribution agreement was terminated by the counterparty. And we understand that there was a deal that was struck with Netflix for the movie to be released on that platform. So we then applied to the SIAC again to appoint an emergency arbitrator to grant us injunctive relief against the counterparty acting contrary to the distribution agreement and granting those rights to third parties. After a hearing and fairly detailed submissions, we were granted that injunctive relief. But in that case, again, there was a third party involved in the form of Netflix, which could not have been party to the arbitration as it was not a party to the agreement. So therefore, we again applied under the Section 9 provision to the High Court of Bombay, asking that the court grant us similar interim relief against the counterparty and also for Netflix to be included in those proceedings and the orders. So the High Court of Bombay again did grant us interim relief in similar terms as the SIAC EA order, and also noted that given that there has already been a consideration of the issue by the emergency arbitrator, whereby he had issued a very detailed order after considering all of the submissions on the facts and the law, the High Court would be granting similar relief as the SIAC EA order. So that's a third example of how I believe the position now in India is that while the Indian courts do exercise their jurisdiction independently under Section 9 and are not bound by such orders of emergency arbitrators, particularly those from Singapore, they can be persuaded on the strength of such an order, not least because an emergency arbitrator who's appointed by SIAC has had the opportunity to look at submissions, has had an in-person hearing perhaps, or a video conference hearing at the very least, and having perhaps even looked at witness statements and so on before arriving at a very reasoned and detailed order. So these are, I think, good examples of how the EA process can be utilized to then achieve an order in India through the Section 9 route. So those are some examples, I believe, that may be useful, even though the general view appears to be that EA orders may not be enforceable under the New York Convention route.
Thank you, Vivek. And it takes on very nicely the point that Ben made, that in many ways, emergency arbitration provisions can be considered or reconsidered by parties. And perhaps Sharan, who's coming on next, can deal with the swiftness with which parties to the Indian courts can get Section 9 reliefs. But before that, I believe Ben and CT have a point to make. Ben?
Sure. I just want to comment on what Vivek said about the amendments to the Act in India in 2015. And of course, the Law Commission, as Vivek has already said, did recommend the introduction of EA provisions into the Act at that time, but they weren't actually adopted. Now, I don't know the precise reasons why they weren't adopted. And I don't know, Sharan or Karishma might be able to comment on that in more detail. It seems to me that all those amendments were done in rather hasty fashion. So perhaps it wasn't considered in a lot of detail. But I would say there are some good reasons for not putting provisions into the procedural law about emergency arbitration. I mean, let's just think about the broader picture here. There's nothing about emergency arbitration in the unsettled model law, and there are no movements yet to amend the model law to include emergency arbitration provisions. There are very few countries in the world that have adopted changed their laws to allow for emergency arbitration. And the ones that have done it in a different way. There are differences between them. So, for example, Singapore and Hong Kong both have included EA provisions into their laws, but in Singapore, as Thye has already said, the definition of arbitrator now includes the emergency arbitrator, but in Hong Kong it doesn't. And there are implications in that in terms of some parts of those procedural laws apply to arbitrators and some don't. And what is the status of the emergency arbitrator in that sense? And even within these laws, there are inconsistencies. So in Singapore, for example, an EA award, if it's made in Singapore and it's enforced in Singapore, it's done so under the provisions relating to an order of a tribunal. But if an EA award comes from outside, from India, for example, and it's enforced in Singapore, it's enforced under the provisions relating to an award. So there are all sorts of inconsistencies. There are all sorts of implications of EA processes, EA awards, and how it all ties up with the New York Convention is very unclear. So as I say, I don't know precisely the reasons why these changes were not adopted in the 2015 Act, but there are some good reasons for leaving well alone and allowing the courts to develop their jurisprudence about this on a case-by-case basis. Because the only way, I believe, of really grappling with the EA, new EA system is to throw out your entire procedural law and start again and write it all the way through the law so that it's properly incorporated in all aspects of the arbitration system. And just tinkering around the edges, as some countries have done, may cause more problems than they fix.
And thank you. And sorry.
I was just going to jump in and say, maybe it's counsel that have got it wrong all this time, and the courts are sort of guiding us in the way that Vivek has indicated that the EA's decision can be a template or a guide or a point of reference for a court being asked to order interim, being asked to implement some form of interim relief. But maybe that the point is this: given that the EA is such an odd animal, and given that the EA's decision is actually meant to hold a particular position until the tribunal is constituted, maybe perhaps what all of us or as counsel ought to be doing is, we have an EA decision, assume it is in favor of the claimant, perhaps then what is necessary is then to go to the constituted or the merits tribunal and have that point confirmed. And once you have that point confirmed, you are away, or you've stepped away from the difficulties of the EA, because you then go into the realm of a proper or of a full-blown award or order of a tribunal. But that's, I'm just putting it out there for consideration.
Thank you. We have a poll coming up because we've tried to make this interactive for the audience. And the last question in the poll is really what you as the audience think should occur with emergency arbitration awards. Do you think that they should be enforceable in India? And if so, should the Indian legislature include that in any upcoming amendments to the Indian Arbitration Act? If we can have the poll up, please. May I request everyone in the audience to answer these questions? Thank you. Can we end the polling, please? Okay, so some of you have applied for defendant interim relief applications in international arbitrations. And coming straight to the question that we were all talking about, question number 4, should India pass laws to allow the enforcement of emergency awards? And 81% of you think yes. Sharan, if I may ask you to take this forward, including the comment that councils have got it all wrong. But before that, if I can please introduce Sharan, who is a star at the Bombay High Court. And in the list of seniors designated by the Bombay High Court earlier this year, he was the youngest on the list, becoming senior counsel at the young age of 42. He started his career at Sidley Austin in Washington, DC, before joining the chambers of Mr. Janak Dwarkadas in Bombay. And he now has a solid commercial litigation practice at the Bombay High Court, also at the NCLT and the Supreme Court of India. He's acted as a counsel in many international arbitrations, including those seated in London and Singapore. Sharan, you've got a lot of questions on your shoulders.
Thanks, Karishma. I, in fact, whilst listening to my co-panelists, felt that some of my questions were answered. So let me take this forward with starting off with the results of the poll. And in one sense, the results of the poll, the overwhelming majority who want legislation in India, doesn't come as any surprise to me at all. Because history has shown in the Indian context that without any specificity in legislation, the law is only as good as till the next judgment. And we don't know when that might be. It may be 3 months later, it may be 6 months later, it may be a year later. I can see some of my panelists smiling. We all know exactly what happened to the state of arbitration law in India when we were governed by the Bhatia regime in respect of Section 9 and on whether Section 9 can be availed of by parties to a foreign seated arbitration. And we all know exactly the kind of confusion and inconsistency that resulted as a consequence of judge-made law, when really the need of the hour is consistency, regardless of the view that that consistent approach takes. So therefore, I feel that, yes, in the Indian context, I definitely feel too that there is a need for specific legislation. And whilst Ben may be right that what was proposed by the 246th Amendment was perhaps not well articulated, I think that this is definitely something that needs to be revisited, because even after the 246th Law Commission report was obviously not accepted by Parliament, you've had a very high-level report which was authored by Justice B.N. Sri Krishna, a former judge of the Supreme Court of India and one of the most renowned arbitrators in India. And this was a report, albeit in the Indian context, on reviewing institutionalization of arbitration mechanisms in India, and specifically in the context of emergency arbitration awards or emergency orders. That report of July 2017 notes that there is significant uncertainty as regards the enforcement of emergency awards, and that comes as no surprise. Justice Sri Krishna, I know that Vivek had opportunity to appear in the Raffles matter and has obviously a very first-hand perspective of what Raffles decided. But Justice Sri Krishna in that report categorically says that the Raffles decision is now a pronouncement by an Indian court that awards passed by emergency arbitrators are not enforceable in India. So that is really at least the perception of what Raffles says. Whether the reality of it is exactly that or something else is a different point. So perhaps it is from this context that, given the proficiency with which and the frequency with which Indian parties are parties to arbitration proceedings outside of India, we heard an interesting statistic that there have been 47 Indian parties engaged in arbitrations in SIAC. And one of the advantages of a well-defined rule of procedure, such as the SIAC rule of procedure, is resort to emergency arbitrations, which is of course well recognized by the Singapore International Arbitration Act. I think that if it's going to become an integrated whole, which is in many ways what arbitration is trying to achieve, and the New York Convention is perhaps a good example of that international endeavor. If this is going to be a successful integrated whole, there has to be more legislative clarity on the status of emergency awards and their recognition and enforcement in India. I think that the problem in India is today not only one of enforcement in the context of emergency awards rendered by tribunals outside of India and under international arbitration rules. I think that the problem in India today is that there is uncertainty as to the status of emergency arbitrators or emergency arbitration awards or orders. I think orders is perhaps the more appropriate expression in the Indian context. Even in respect of arbitrations which are situated in India or seated in India. I've noticed that many of the Indian arbitration institutions, such as the Delhi Center for International Arbitration and the MCIA, that is the Mumbai Commercial and International Arbitration, Mumbai Center for International Arbitrations, have adopted a set of rules which obviously to me parallel and have been guided by the SIAC rules in making provisions for emergency arbitrators, how they are to act, the time frame within which they are to act. But even in respect of those arbitrations which would be seated in India and would be what we would call Part 1 arbitrations in the Indian context, there is still an extremely grave question mark as to whether the orders passed by emergency arbitrators would be orders of the tribunal or of an arbitral tribunal itself. So it's from that perspective also, I think enforcement is one leg of the problem. The other leg of the problem is closer home, which is how would the Arbitration Act, the Indian Arbitration Act as being the law of procedure or the law, or what we would say curial law to the arbitration, how would it recognize emergency arbitration orders even for those arbitrations situate in India? Speaking for myself, I can see an entire range of problems if emergency arbitrators were functioning not as tribunals but as some kind of creature outside of a tribunal but yet binding upon a party. And that is because every provision in Part 1 of the Indian Arbitration Act, which applies to arbitrations seated in India, in terms of giving arbitrations efficacy, is relatable to the existence and orders being that of an arbitral tribunal. So if we were to concede the position that the emergency arbitrator is not a tribunal, I believe that we will have innumerable problems in terms of efficacy of emergency arbitrations, even in the domestic context. So therefore, the first challenge is that in the absence of clear legislation, is it possible to argue in the Indian context, even under Part 1, that an emergency arbitrator is a tribunal? Now, I've had a look at the provisions, and in the absence of an express provision, I'm happy to say, and because ultimately as a practitioner, our instinct is always to find something which is more efficacious rather than something which is going to frustrate the process of arbitration. And my perception is that even absent express legislation, a more than tenable argument can be made that emergency arbitrators would, if constituted under applicable arbitration rules, act as an arbitral tribunal. Yes, they would not be the tribunal that takes the reference to its logical conclusion be it a final award or an interim award, but there would be a tribunal. And why do I say so in the Indian context? I say it for two reasons. One is that under Section 7, subsection 5 of the Indian Arbitration Act, the Arbitration and Conciliation Act, an arbitration agreement can also be contained in a document which is referenced in a contract signed by the parties. Now, that document would also include the rules of arbitration applicable to an arbitration that the parties have agreed upon. So if you are having an arbitration in accordance with rules which provide for an emergency arbitrator, it may well be said that that is therefore in the first instance contemplated by the arbitration agreement itself. That takes care of one problem. The next problem is, what about constitution of the tribunal? There again, the Indian Arbitration Act has got a clear leaning and mandate towards party autonomy in Section 11(2) of the Arbitration Act, which says in the first instance, the tribunal must be constituted in the manner agreed upon by the parties. That immediately takes you to the set of arbitration rules. And those arbitration rules contemplate the appointment of an emergency arbitrator to act as a tribunal, because fortunately that is indeed the language used in the SIAC rules, as also the language used in the rules of some of the Indian arbitral institutions, that the emergency arbitrator acts as the tribunal. So that being the case, 11(2) of the Act says that the party autonomy in the procedure to appoint an emergency arbitrator must be given primacy to. And if, of course, you cannot agree, then you may go to court under 11(6), or even if the institution so appointed does not appoint an arbitrator. So that again, in the absence of express legislation, is a provision which would assist in the treatment of an emergency arbitrator as a tribunal and not a creature outside that of a tribunal. And the third and very important question that I had in my mind was that if the emergency arbitrator is a tribunal, then how do you transition from an emergency arbitrator to the main tribunal, to borrow Ben's expression? Because that transition is not something which is common absent an emergency arbitration situation, as in between one set of arbitrators to another, there would be a process to be followed. And the answer to the transition between an emergency arbitrator to the main tribunal, according to me, again, a provision not perhaps intended for this purpose, but clearly a provision that would assist us, is Section 15 of the Indian Arbitration Act, which says that even the substitution of arbitrators to a tribunal is a matter to be in the first instance determined by the procedure agreed upon by the parties, as also the termination of the mandate of a particular arbitrator. If one has to look at it technically, that this is now one tribunal ceding way to another tribunal, Section 15 of the Indian Arbitration Act, which deals with termination of mandate as also substitution, also recognizes the principle of party autonomy. Section 14 discusses termination of the mandate when it's de jure or de facto impossible to act. But Section 15, perhaps more apt in this situation, deals with what I would say is the transition from an emergency arbitrator acting as a tribunal to the main tribunal. So I'm happy to say that although these provisions, when looked at in juxtaposition with each other, were not perhaps intended for emergency arbitrations, at least to the extent of emergency arbitrations in India, I believe that a more than tenable argument can be made that notwithstanding the 246th Law Commission not being accepted, it is a process and a resource which is otherwise capable of recognition within our arbitration framework, because if it was not, I don't think it has any existence outside of it. Coming to the question of enforcement, Karishma, and I just wanted to say that, yes, I do tend to agree with Vivek that enforcement is a strong word, and there has been a history of precedent where Indian courts have looked at how they can utilize emergency arbitration orders and awards. But there is one more judgment that I want to talk about, which Ben briefly mentioned, and I'm sure he'll come back on this, which is in Ashwini Minda's case. And the point I want to make about that judgment, it's really a question more than an answer. But the question that I ask myself is that does the reasoning of the Delhi High Court single judge, and more importantly, the appeal court in Ashwini Minda, bring us closer to the recognition of emergency arbitration orders as being an order or an award which is per se enforceable in India? It does not answer the question categorically, but my point is, does it take us a step closer to those orders being capable of being put into enforcement. And the reason why I think that the decision of the Delhi High Court takes us a step closer and certainly advances this jurisprudence more than the Raffles decision did is because what I found extremely interesting in the appeal decision in that case was that the appeal court of the Delhi High Court did not confirm the single judge's view that merely because you have accepted the JCAA rules, you have accepted or impliedly barred the applicability of Section 9. That's what the single judge said. The single judge said that by accepting JCAA rules, there is an implied bar of Section 9 and therefore held the Section 9 application to be not maintainable. The appeal court does not go down that path and it expressly leaves that question open. So it does not confirm the single judge on there being an implied bar of Section 9 to a foreign seated arbitration. What the appeal court says, and this is what the point that I wanted to make on whether it takes us closer to enforcement. The appeal court says is that the minute parties have accepted that there will be recourse to an emergency tribunal or an emergency arbitrator under the JCAA, would that preclude the Indian court's jurisdiction under Section 9, subsection 3 of the Indian Arbitration Act? Now, 9.3 is a provision in Part 1. 9.3 says that when a tribunal, obviously in the domestic context, is constituted under Section 17, then unless you establish that the tribunal will not be able to give you an efficacious order, you cannot come to court. So clearly and patently, 9.3 was never intended to apply to a tribunal of an emergency award arbitrator situated in Japan. Yet the appeal court said that we are going to invoke 9.3, and according to them, they were not doing violence to the language of 9.3. I'm not entirely sure of that, but the intention is, I mean, it's well intentioned. The appeal court invokes 9.3 and says, because you have invoked the jurisdiction of an emergency arbitrator under the JCAA, according to us, 9.3, when purposively applied, precludes you from now coming to court under Section 9. Therefore, it doesn't do it on the question of maintainability or an implied bar of Section 9. It does it because it says you have already taken recourse to a tribunal outside of India. And it also then invokes the common law doctrine of election to say that once you have elected, you can't come here. What is the net effect of all of this? Whilst, of course, the appeal court was not squarely dealing with an issue of enforceability, I find it difficult to imagine that the appeal court invokes a limitation of 9.3 in respect of an emergency arbitrator in Japan without actually believing that that order will have any value in India. The consequence of the appeal court invoking 9.3 is that the appeal court necessarily felt that the order or the emergency order or award rendered by the tribunal in Japan will have efficacy in India. Because if it felt that it did not have efficacy in India, 9.3 would never have been available to it at all. Hence, the invocation of 9.3 by the appeal court, in my opinion, definitely takes us a step closer, albeit not there entirely, to Indian courts now accepting that we must find a way of giving recognition to emergency arbitrator awards and orders. And so does the invocation of the doctrine of election. Because again, the doctrine of election is predicated on a mutually exclusive choice where one party says, I am going to now make choice A and is therefore precluded from making choice B. If we were to now look at emergency arbitration as a gray area which does not preclude choice B, it means that the doctrine of election would not have been capable of being invoked. So whilst the appeal court does not squarely deal with enforceability, and I concede that, neither does it deal with how it will be enforced, how it is efficacious, it is apparent from its reasoning that it is now elevating the status of emergency arbitration awards and orders so that you can't now come to Indian courts under Section 9, and it has read in limitations to the Section 9 jurisdiction, not on the point of maintainability. I do feel that is a good development, and whether the next judgment is going to view it in this manner, no one knows. Whether it's the fault of counsel or whether it's the good work of counsel, I mean, CT says that the counsel have got it wrong, but in every litigation, one counsel gets it wrong and the other one gets it right. So perhaps it's 50-50. So those are my thoughts on the position in the Indian context, Karishma. And thank you to you for this question and to my fellow panelists.
Thank you very much. Sharan, you and I as counsel are outnumbered on this tribunal, and we have Ben sitting as arbitrator who has a point to make about something that you raised. Ben.
Yes, thank you. So I entirely defer to Sharan on Indian law, and I won't dare to question what he's just said. But I just wanted to point out one point about the EA rules within arbitration rules, or within the SIAC rules, within the JCAA rules. And just to highlight, there are uncertainties within those rules about what the EA is. I mean, if one reads through it, the whole set of rules, it's difficult to work out sometimes whether the rules are referring to the EA as an arbitrator or an EA as something different from the arbitrator. I mean, in the SIAC rules, for example, the definition of an emergency arbitrator is as an arbitrator. But then the definition of tribunal refers to these other arbitrators. And there's a distinction between the EA making the award and then passing it on to the tribunal as arbitrators to change their awards. So there is frankly a lot of confusion in some of these rules between what actually an EA is. So I don't blame judges in Delhi or Mumbai or wherever in trying to try to understand what this is, because it's not really been set out in perfect clarity within the rules themselves. And I also just wanted to flag this other possible interpretation, which is that the EA, rather than being an arbitrator, could be seen as a representative of the institution. And there is precedence for this, because in the 1930s to the 1950s, the ICC had a system whereby the ICC court itself could issue an interim measure before the tribunal was appointed. And in fact, it was the president of the ICC court who did that as a representative of the institution, not as an arbitrator. So that's another possible way of looking at it. If you look at the English Act, that still has a reference to that, because it talks about the institution issuing measures in addition to the arbitrators issuing interim measures. So that's another possible interpretation here. And let's also not forget that the EA process was invented by institutions themselves. It originally comes from the AAA in America, and then there's been a ripple effect with other institutions adopting it. It's not come from legislatures throughout the world. It's not come from UNCITRAL or anything like that. It was a bright idea thought up by some institutions that has been copied everywhere. So again, I don't blame courts and legislators for grappling with this process. It's been, if you like, forced upon them. And there are many different ways of looking at it, and they do all have to deal with it in as best they can.
Ben, thank you. I think we have just perhaps time for one or two questions, and there are two that can be combined in one. We have a question from Kalyani Deshmukh, and perhaps Vivek and Sharan, if between you can take it. Why should a party not directly approach the High Court instead of taking a route through emergency arbitrations? Would it not save time? That's the first. And the second, also along the same lines by Vivek Gambhir, is what is the advantage in seeking an emergency award if one has to make an application under the Indian Arbitration Act to seek enforcement of the interim order? Vivek first.
Okay, sure. If I can just answer them in turn, or rather maybe just take them together. I suppose there's some benefits to having an EA order in place, even if, say, a counterparty is in a different jurisdiction from Singapore, where you might ultimately need to go to a court for similar interim relief. One is, of course, that the EA process itself is, fairly detailed, and the manner in which the EA considers any such application is fairly detailed. As I said, there are, a set of submissions that go in, they're inter parties, parties are heard, and there's a detailed order. And that order is something that stays for posterity in the arbitration itself, which is available to the tribunal as well. It may also be brought up before a tribunal in a bid to modify it or vacate it or confirm it. So as a claimant, that is something that you may want to have in the proceedings, in the arbitration, right from the word go. The second reason why you may want to go to an EA first is, again, which jurisdiction is the counterparty from? Say in the Raffles case or the Hotel Mumbai case that I was involved in, we did have counterparties that were based in Singapore, although there were other counterparties that were based in India. And particularly in Singapore, given the state of the legislation, where you can easily convert an order of the EA into a judgment of the Singapore High Court, there is great benefit to having that EA order in the first place. Even where the parties are not based in Singapore, there is still benefit to converting an EA order, say in a Singapore-seated arbitration, into a High Court order, because then that has teeth of contempt. It may very well be that an Indian party or an American party has presence in Singapore, has directors who are based in Singapore, which can be used against them in some ways. So those are a few reasons why you might still want to go to an EA. But of course, there are other cases where it makes no sense whatsoever to go to an EA at all, and you are better off approaching, say, a court under the Section 9 rule. So I'd say it's horses for courses, really.
Thank you. Sharan?
Yeah, Karishma, I'll just add briefly a couple of points to what Vivek said. I think that one of the determinants of whether you would go to a court or whether you would invoke the emergency arbitrator procedure would, to a degree, also depend on whether there are parties to your interim relief application who are not parties to the arbitration agreement. And I speak in peculiarly in the Indian context, because at least under Indian law, at the interim stage, courts have recognized in principle that to some degree, not entirely, interim reliefs can be directed against a non-party to the arbitration agreement, whereas there is a complete limitation in that sense if you were to seek interim relief before the tribunal. And that would, of course, be a clear indicator. And more I'm seeing in Section 9s, the nature of reliefs are such that they would touch upon third parties to the arbitration agreements. And if that was ever the situation, I think that EA would not be effective. The other consideration to add, of course, and this is more practical, is that at least in respect of an Indian-seated arbitration or a Part 1 arbitration, and if I was to advise, as much as the EA procedures and the rules are extremely well developed in Singapore, the concern that I would have over here is pretty much the concern that I articulated when I was speaking, which is that do you want to be the first case or the pilot case in India on what is the status of an order rendered by an emergency arbitrator? And I feel that, well, someone has to bite the bullet, but the question is whether you want to run the risk for people who are going to follow after you. And from that purely practical perspective, I would obviously lean towards the tried and tested of Indian courts. And I may also say this on timing, that whilst, yes, Indian courts have, perhaps people talk about the long gestation of cases in India. That's, of course, more peculiar to the final disposal of cases. In Section 9 matters where we seek interim relief from courts, it's certainly not unheard of where within the first 2 or 3 days of filing, you get some form of protective order. I mean, that happens day in and day out in a commercial jurisdiction like Bombay and I'm sure Delhi. So it's not as if that is necessarily a factor which leans against courts. I mean, you'll get your initial ad interim opportunity very soon after filing. What you make of it is a different matter.
Thank you. We have many more questions, but unfortunately not enough time to take them. And so if I may, thank my panelists and also just a short story from my early days at the English bar. So my head of chambers was preparing me for an appearance at the Court of Appeal in London. And he said I would feel similar to a conductor conducting an orchestra, trying to keep some instruments playing while making others fade. And I should say that the panelists have produced a melodious outcome today, and I thank them for making my task easier. and perhaps the audience, we don't have another poll, but if we put a poll to arbitrators on this panel versus counsel, it remains to be seen next time which one emerged victorious. But thank you everybody for attending, and thank you panelists.
Thank you.
Thank you.
Thank you.